You'll also note that subsequent to August 2025, the correspondence focused on sort of ancillary issues like...
Oh, I don't really want to get bogged down in how far. Let's just say it's been a while. Can you agree to that? It's been a bit since January 2025.
Since subsequent to August 2025.
There's been some dialogue for a while. What is a state official to do in that circumstance?
State official is to do what the Secretary of Administration and Finance did in that case, which is to bring a claim for declaratory judgment that the Attorney General has been arbitrary and capricious in exercising her authority to control the state's legal policy. That's not what happened here. The auditor chose, instead of teeing that issue up properly before this court or another court, to simply declare herself done with the conversation and file the case that she had been given permission to file.
As a practical matter, now that the Attorney General has intervened and filed the motion to strike, what's the difference between that posture and what is the limited question before this court?
Between the posture of had she brought a claim that the...
Right, aren't we now at the point of needing to figure out whether the Attorney General can stop this litigation from going forward or not? Isn't it effectively the same as a declaratory judgment in Secretary of Finance?
I think that's sort of a dangerous road to go down, Your Honor, because that sends the message to the extent that this court were to indulge in that analysis.
Whether the Attorney General can stop this litigation from going forward or not.
When they're done with the Attorney General's due diligence process, whether it's after 1.5 years or 2 months or not at all, and simply get their ticket to court by filing the lawsuit that they haven't been given permission to file.
Is there what's left in the due diligence?
What's left of the
what are the outstanding questions that the Attorney General needs answers to before it can make a decision as to whether or not it will represent the state auditor?
So let me split that into two, because there's actually two questions. There's the question of representation, but before we even get to the question of who represents who, there's a question of, do we authorize litigation to go forward? Because one possible answer here is that the Attorney General could authorize the auditor to proceed with litigation and not represent either party. So those are, in theory, two different questions. There are substantive questions that remain as to the scope of the audit and the scope of the documents that the auditor is seeking.
What about the three topics that have already been delineated since January 2025?
Those have been delineated.
And they're actually in the complaint.
What has also been delineated is the desire to proceed with what the auditor could not pursue as a part of her earlier audit of the legislature, which was far more broad. And the Attorney General has asked those questions in an effort to not to avoid a situation where we have serial litigation before the court.
So let's just assume it's the three topics that have been identified. What other outstanding queries does the Attorney General have for the state auditor?
So there is also a threshold question, which is that last October, when the Attorney General's office essentially asked the auditor's office, listen, if we authorize a lawsuit within certain parameters and we authorize you to have a special assistant attorney general pursue that lawsuit within certain parameters, will you agree to abide by those parameters? And the answer was no. So in order to...
Where was that answer given that the state auditor said, I will not agree to abide in the litigation that you authorized pursuant to a SAG, a limited scope to these three topics?
That's on page 227 of the record appendix. And the way that that came up is in the course of the correspondence between the parties. We, on August 4th of 2025, in correspondence to the auditor, said that were a SAG to be appointed to pursue litigation on your behalf, any such appointment would be expressly limited to a particular cause of action against specifically identified defendants. And that's not unique to this case, by the way. That's how it works in every case of affirmative litigation. And we asked for a commitment to abide by the scope of that authorization were it to be granted. And the response we got was that the auditor would not make a, quote, blind commitment to abiding by the scope of SAG authority and or assent to the intervention of the Attorney General should she stray outside the bounds of the authority that were granted. So we have sort of two buckets of questions, right? We've got the substantive questions and trying to tee this up as best we can for a court to avoid protracted and serial litigation in which a dispute between two parts of state government is aired in our courts. But we've also got the threshold question of if and when we authorize such a lawsuit, which, by the way, we've represented in our briefs and all the way through that we are more than willing to do once we advance the conversation.
What have you said you're willing to do? That's one thing I can't figure out, because there are 3 targeted requests. I understand the point you made about they may not be a commitment to abide by those 3 requests, but there are 3 particular requests, non-disclosure agreements. I can't remember the other. The third one I'm not familiar with at all, but
Balance forward line item.
yeah, what does that mean?
I believe I'm not a legislative expert, but I believe that's money unspent from the prior year that then rolls forward.
Okay, so you've got 3 pretty precise requests. Can't we, and ultimately you two don't get to decide to leave it in limbo indefinitely, because the people have an interest in having that resolved, and this court ultimately decides whether that's constitutional or not you, right?
Right.
So how do we push this to resolution so the people get at least a determination whether that's constitutional or not? Those 3 items.
So the challenge is that representation, that what they're seeking is those 3 or 4 items, has been wildly inconsistent over the course of
But let's say we agree with you, but we say, look, those 3 items we need to make progress on. You're both battling each other to exhaustion and we're going nowhere. But don't we have to push that forward? And isn't that something we can do?
I don't think that would be an appropriate path for this court, because
Making you two resolve what the case is about so that this court can decide whether it's constitutional or not. We don't have any say over that?
unless you find, and this, as I said, has not been properly teed up before the court, the only question that has been reserved and reported today is the motion to strike the complaint. But putting that aside, if you were to move on and examine the question of whether or not the Attorney General's conduct has been arbitrary and capricious.
Oh, but it's, in that case, at a certain point, this court decides whether something's constitutional, not the AG. Right. The AG decides on defense, but you can't indefinitely prevent this court from deciding a constitutional question, can you?
And that's not our intent.
But that's the effect.
It's only
That's the practical effect, because although you mentioned that this might, in your view, be a squabble between two different parties, you're leaving us out. In the effect of it effectively prevents any court from passing on the validity of the statute. And doesn't that make that part, the part that leaves us, or is essentially freezes us out until you guys or the AG figures out what she's going to do, isn't that, I guess, qualitatively different than ordinary discretion cases for you? Because of the part that we still get to pass on the constitutionality of it.
Except that it's only been dragged out because of the conduct of the auditor. The Attorney General.
Both sides have dug in.
Right.
I mean, I don't accuse you as one of the amicus of a rope-a-dope, but you both are sort of stuck and not moving. And the people are waiting for an answer.
I mean, listen, if that's the path that the court chooses to take, the Attorney General is an officer of this court. We will abide by the direction we are given by the court. But I don't think that question
that's not controversial, though, because judges do this all the time, right? So parties parties don't agree. You can be a district court, superior court, whatever court you happen to be in. The court says, go out and work it out. You go out and talk about it, and come in with an agreement that works out your issues.
So 2 things. First of all, they do that when there is a properly presented case before them. And as I've said, I don't think the question of the Attorney General's conduct is properly before this court.
Well,
But even putting
you
that,
say that, but you're making it seem as if that's the only vertical within which the auditor could proceed, just because that's the way that other parties before her had done so, by bringing a deck action. But that we've never said that's the only way that the conduct can be challenged.
you've also never said that a state official, when she decides she's done talking to the Attorney General, can just unilaterally file the lawsuit that the Attorney General has not authorized.
May I ask you a couple of practical questions?
Sure.
In the ordinary course, when the Attorney General has made his or her decision, and that is communicated to the agency head, what happens next? And let's say that the decision is, we don't think you can bring this suit, we're not going to take it on. What would you then do?
So typically, so there's two versions of that answer. There's, we don't authorize that suit and we won't, and therefore I guess the question of representation is immaterial. Or there's, well, we're not going to represent you, but we think there's a good faith question that you're entitled to bring before the courts, and so we'll authorize you to do so through.
So that's where I get stuck, because the AG hasn't decided for whatever reason. I am not blaming the AG, I'm not blaming the state auditor, but there hasn't been a decision. Yet there is this statute that permits the audit of the legislature, and the three topics, let's just say they've been agreed to, or at least they've been identified as the limits of what the current complaint is about. Why, on that topic, what's the AG's position? Is there no legal merit to the auditor's position? Or is, or you know, are you in that camp? Or is it just that there may be legal merit, the AG is just not willing to represent the auditor? Which one is it? Which camp is it?
So I think our position at the moment is that there may be legal merit as to some of it, or if not legal merit,
As to those three topics.
at least a claim that ought to be put before the courts to decide.
So you could go forward with those.
But it is also within the Attorney General's discretion to determine how those questions are teed up for this court, so that we're not having one case about those three requests, and then in 6 months, we're before the court again on follow-up requests.
Why do we have to determine the extreme, full extent of the statutory authority of the state auditor under this mandate by the people? Why do we have to have that case? We usually don't decide cases that big. We decide the very narrow cases that are with us. And to the Attorney General's credit, at least as I read the correspondence and as I read your brief, even here, those are the three topics that have been identified. So why can't we decide as to those three topics, whether there's legal merit to that or not, whether the legislative privilege prevents it or not, whether we have the power to mandamus the legislature, all of those kind of constitutional questions as to those narrow issues. I don't understand what the AG's unified legal policy is against bringing that forward.
So yes, this court or another court could pass on those questions.
No, I'm not asking you what we could do. I'm wondering what the AG's policy is in preventing those three issues from coming forward. Why not?
The AG's policy, as articulated in our brief, is that generally we try to resolve interbranch disputes.
Right, and it's been a while. These questions have been out there. These three topics have been identified. You say not nearly since January 2025. As I read the correspondence, I come to a different resolution, but it's been a while. And there hasn't been an amicable resolution. I'm assuming the AG is working with the legislature. I know the AG has worked with the state auditor. There hasn't been an amicable resolution that prevents this issue from coming to where it needs to be decided, which is usually the judicial branch.
There hasn't been an amicable resolution, but that is not the end of the inquiry. First of all, in order to determine the nature of the dispute that still exists between the parties, that's in part why we've been asking for the auditor's position on issues like legislative privilege.
And well, I'll ask the state auditor, but it seems to me that she's taking the position that it's these three issues. These three topics.
She has most recently, and at
And since
various
January 2025, it's in the correspondence from January 2025. It's there. The three topics are there. It's in the audit request to the legislature. There have been statements, I'll grant you, that have questioned whether she's actually limited to the three, but the three have been identified.
Well, there have been more than statements. There's a representation in their brief to the effect of this is where we start, but we're not promising this is where we end. And by the way, we're not asking for a commitment that here's a list of documents we want and we'll never ask for anything more. We're asking for a good faith engagement with the question of what do you reasonably foresee needing right now?
Can I shift you to another part of it, which is my sense is you're focused very much on the mandamus issue. When I read through all that correspondence, you've got the three, whether you're going beyond the three questions, and I understand why you're concerned, because you don't want to let them go out and litigate and start and then try to go beyond that. Although I assume you can limit what they can do. Is that right?
Well, the way we would limit what they can do is by granting the SAG authority within certain parameters, which they've told us they won't promise to abide by, and then we'd have to intervene.
But you litigate it. You decide to represent them and limit it to those three issues and refuse to do anything more. That's even
right.
simpler. But let me take you to mandamus, because I understand that's much more complicated. That you don't believe that you raise questions whether there's the power to issue a mandamus against the legislature. And I get that. But there are also cases that you cite in your brief that we basically say, let me just read. We basically say we expect the legislature to comply with a decision of this court, even without a mandamus, right? I'm just looking at the 436 Mass 144 campaign and political finance decision. And we basically say that, we expect the legislature, once we've issued a decision, to comply with it, even if it's not a mandamus, right? We've issued decisions to that effect, right?
Yes, if it is in the nature of orders with which the legislature can be expected to comply.
So the Queen election case, those were cases where we said that mandamus was available? Because we make this point in at least two cases, right?
Yeah, I think that, are you referring to Bates, Your Honor?
Yeah, I'm referring to Bates and the case that Bates relies on.
I don't have the text of Bates in front of me, Your Honor.
Presumption, here's the key language. The presumption exists that the Commonwealth and its officials will honor their obligations. And wasn't that done in a case in which mandamus was not available? I thought that that's Chief Justice Marshall's point, that we expect them to live up to it even outside. Maybe I'm misinterpreting that case, but I thought that was outside of the mandamus context. But I think you're getting a rescue over there. So. Mm-hmm.
Here's my lifeline. So that's about the legislature appropriating funds to satisfy a judgment. It would defeat the case law that says that the legislature can't be subject to a mandamus order if you could just issue it as something else and expect the same compliance.
Isn't that exactly the point here? You couldn't compel the legislature to do something, but you expect the legislature to comply with the law, right? Isn't that what we said in that case?
You do expect the legislature to comply with the law, absolutely.
So why isn't that something that you can be comfortable with? I'm not saying you're going to give us a decision on your merits, but do they have a good faith argument on these 3 points that justifies going forward? I understand you're uncomfortable and they're not committing to other things, and this may not be possible right immediately, but those 3 issues seem confined, and it doesn't seem to depend on whether mandamus is available if that case is on point.
So even if we agree with all of that, I don't think that's the question before the court today. And if the court goes in that direction.
What do you think the question is?
I think the question is whether or not the complaint ought to be stricken.
Chief, may I ask a question?
Yes, of course.
One of the suggestions in your brief, as I understand it, is that the Attorney General would be open to some kind of order that required the parties to do something further, I suppose, to try to reach a resolution regarding how to proceed. What would such an order look like in your view?
So an order could say the auditor has to answer particular questions or provide requested information by a particular point in time, and the Attorney General ought to make a decision, either yes or no, in a particular period of time after that. In order,
Perhaps, would it not make more sense, given how the correspondence has gone so far? And I think we've probably all dealt with clients with whom there's a communications breakdown, that maybe the AG identify what it would be willing to proceed with, rather than continuing to ask the same questions and continuing to get the same kinds of responses where there doesn't seem to be any ability to move forward from that tango. Perhaps.
if that would assist the court, we can.
Well, no, I
endeavor
mean,
to
we,
do that.
I can't imagine an order really where we would micromanage to that degree. So the question is, what would the order say? In other words, it is hard for me, looking at the history of correspondence, to think that an order might be useful if we're just going to repeat the same cycle of unproductive communications. It seems to me perhaps that a deadline would have to be set by which the Attorney General would fish or cut bait, to use, common phrase. Is that the kind of thing that you see as being reasonable? And if so, what date would that be? What kind of date would we impose? I mean, courts do impose such dates. What would be a reasonable amount of time?
I don't think it would require a lengthy period of time.
A month?
10 days?
30 days, yeah.
Okay.
I want to be clear.
And then what happens at that? So can you play that out for me? We say, order, Attorney General has to fish or cut bait within 30 days. We would find some other phrase for fish or cut bait. And then the parties would file a report just saying, or perhaps it would only be the Attorney General who filed a report saying what it is that the Attorney General had decided, and then we would wait to see what happened, correct? I mean, would the underlying complaint here, whatever the Attorney General's answer is, still be struck because that complaint was not crafted with the input of the Attorney General, correct? So the next complaint would either be crafted with the input of the Attorney General or with whoever counsel is, whether it's a SAG or some independent counsel, but it would proceed in some other fashion. That's what I'm thinking that might be what the mechanics of such a process would be.
I think that's right. I think that assuming we get to where the Attorney General the point the Attorney General has been trying to reach, which is that we can authorize something to go forward, that could be accomplished either by striking the current complaint, substituting the new complaint, amending it to conform to the parameters of the Attorney General's delegated authority. It doesn't necessarily have to be a brand new case. But I think at the end of the day, what needs to happen is that if the Attorney General authorizes a complaint within certain parameters, then that becomes the operative complaint in the case, not the one that is before the court today.
What's wrong with the current complaint? I mean, other than it wasn't authorized by the Attorney General.
Well, that's a
in
biggie.
terms of sum and substance of it.
It doesn't state a cause of action. And it wasn't authorized. I don't know that those are the appropriate defendants against whom the Attorney General would authorize a claim were she to authorize one. And so, typically what happens when an agency comes to the Attorney General seeking permission to file affirmative litigation, often they come to us with a proposed draft complaint, and we go back and forth about what that complaint looks like. Even when they don't, or when the Attorney General is not going to represent, we might grant them the permission to file a complaint subject to our review of the complaint. And we go back and forth about, are these the appropriate parties? Are these the appropriate causes of action? Are the facts laid out sufficiently to pass, Rule 11?
Is this further complicated? Is it further complicated by the fact that we got three parties here? We have the legislature as well, and you're also involved with the legislature. So that does make this more complicated, right? Because you may be representing the legislature in this as opposed to the auditor, right?
We might. I suspect the likely outcome is that we might end up representing nobody, and the Attorney General weighs in with her view of the law that, lies somewhere in between the two extremes of the two parties. Yeah, that is also a possibility. But we can't, it is really difficult to answer those questions until we know what that appropriate complaint looks like.
We can tailor the issues that you have to resolve in this 30-day period. We can provide some construct to that, right? Because again, ultimately we have a law there's no resolution on. So I think the answer to that unsatisfyingly is yes and no. I think you can. But what I also think is true is that the Attorney General can exercise her discretion to control the legal policy of the Commonwealth in any manner she deems appropriate, so long as it's not arbitrary and capricious. So if there is some question that were not on the court's list of questions, is it an error of law that rises to a constitutional level? That's included in arbitrary and capricious, right? Meaning your non-enforcement of a statute. I'm not saying that's this case. At a certain point, the AG can't decide, I just don't like a law and I'm not going to enforce it, right? At a certain point, it becomes our business. Now, they may have to sue you rather than the legislature, and that may have been the appropriate way of doing this. But
folks, I just
at a certain
thanks for
point,
joining. I just want to say the statute lawsuit has not come forward yet. It's the next one on the docket. They're talking about the state auditor, Diana DeZaglio, trying to fulfill what happened. The state voters voted to have the legislature audit it, and Andrea Campbell, the AG, is preventing that. And so now it's before the SJC.
judgment. That's not what's happening here.
Okay.
But I think
So what is the
that would
uniform legal policy that's precluding this from going forward?
The uniform legal policy is to prevent, to try to resolve interbranch disputes to the extent possible without help from the courts, and to the extent that we must ask the courts.
Is that exhausted at this point?
I don't know that it is, because part of the challenge with the remaining uncertainty about what it is the auditor's looking for is the challenge that we have when we go to the legislature and we say, okay, what's your position on that? Right? If we don't have a clear answer on what it is we're asking in that question, then we can't get a clear answer from the legislature. But even aside from that, I also think that there is a clear legal policy within the discretion of the Attorney General to try to, if that fails, and it may well sometimes fail, and maybe this is one such case, to try to tee it up for judicial resolution in the most efficient way possible, right? To avoid the serial litigation to the extent we can. And I think that is a reasonable exercise of the Attorney General's discretion. It is not arbitrary and capricious. This is not a case where, for example, the Attorney General has just refused to engage with the auditor at all, has not responded to her request for litigation. We've asked questions. The auditor disagrees as to whether or not we've gotten our answers. This court may disagree as to whether or not we've gotten our answers. But the Attorney General's reasoned judgment that she has not gotten those answers to her satisfaction is not arbitrary and capricious.
Okay. Thank you
Thank
very
you.
much. Okay, Attorney Lise Reardon.
Okay, now I think the AG.
Good morning. May it please the court. I'm Shannon List-Reardon on behalf of the state auditor. With me is Michael Lung-Tat, the general counsel for the auditor's office, and Trevor Byrne. So This case raises the very important question of whether the Attorney General can unilaterally effectively block enforcement of a voter-approved law approved under Article 48 by preventing access to the courts by another co-equal constitutional officer who seeks to enforce it.
Counsel,
Is there a
can you
reason?
be, I'm sorry.
Is there a reason that you didn't first start by bringing a complaint against the Attorney General for not moving forward with this?
Well, I believe, as Justice Wentland pointed out, effectively we're at the same place now. And in the Feeney
No,
case,
that's actually not my question.
okay, sure. In the
Because
Feeney,
I'm asking a procedural question.
Yeah.
Why is it that you didn't begin with that as opposed to jumping ahead?
because there's no legal requirement that that be done. In the Feeney case, this court addressed this type of issue in the course of the underlying litigation. So there's no rule that says that a declaratory action needs to be brought against the Attorney General in order to tee this issue up for the court.
But isn't that the way you should have done it, though? Because the fight is between you and the AG right now on representation, not you and the legislature on representation.
Right. Well, but the issue is teed up because the Attorney General intervened and moved to strike. So effectively, we're here. Now, if you were to say we needed to go back and do that, it will just be more delay before the people get an answer to this question because a case may be brought. It could very well be brought in federal court. We then may need to wait for the federal court to certify the issue.
But as Attorney Sturman brought up, this will send the message that anytime somebody from the executive branch decides, any state agency decides that they don't want to wait and they don't want to go through that procedural hurdle, that they can just do as you did.
No, that's not correct because the court here could cabin when such an action is appropriate. So this is an unusual case. I think all the parties
Are you
agree.
prepared to do that? Are you prepared? Is the auditor prepared to limit this to the three issues? Because when you read the correspondence, you keep saying, okay, when we do an audit, we can't be bound by what we start with. So are you prepared to limit this to those three issues which are defined for the time being? It doesn't mean you can't bring a separate lawsuit where where we go back and decide this issue again, but are you prepared to confine this to those three issues?
Yes, the audit, in the correspondence, the record makes clear the auditor has repeatedly said that this case would be about the document requests that were already served in January 2025. And this court just last week.
I'm being more, because I've read through those. They're not the clearest correspondence on earth. Are you telling this court, because we have to issue some kind of order in this case, that all the auditor is seeking is representation from the AG on these three particular audit requests, and the authority to proceed on those? Because that will clarify what we have to do.
If so, can you please be even more precise and say exactly which letter you're referring to?
Yes, I'm referring.
So which audit demand letter?
Yes.
Is it the January
9th
letter?
Yes, the January.
So you're going to confine it to that?
The January 3rd document requests and followed up by the January 6th specific transmittal of the document request. The state auditor has repeated throughout the correspondence, this case simply seeks to enforce those requests. Because anything beyond that, the state auditor was aware of this court's jurisprudence that this court cannot answer hypothetical, unripe questions, as this court just affirmed last week in its advisory opinion regarding the public records ballot initiative. The court said, well, the Attorney General completely consistently keeps saying, well, it's the Attorney General's position that litigation should not be piecemeal. Everything should be crystallized in one case. This court has specifically said that it cannot decide unripe hypothetical issues. The state auditor has not issued any other document requests. This is about these requests.
The January 3rd letter is the one at Appendix 310?
Correct.
That's what you're prepared to confine yourself to right now?
Well, as it was elucidated in the January 6th letter at Appendix 313, correct. That's what this case is about.
So then there's no problem.
I don't see why there is a problem because the Attorney General has never even said that it has an issue with those requests. And under Secretary of Administration and Finance, this court said that it is only where the Attorney General believes there is no merit to an appeal,
Well,
the Attorney General can refuse representation at all.
can I, just to push back a little bit?
Sure.
Because in the January 6th letter, you expressly, not you, the audit manager, expressly reserves the right to expand those categories and to make future, but that complicates the inquiry that's presented here for now. Because if you're saying we're asking for what's in January 6th, then January 6th is an unlimited ask. In other words, it's these 4 things plus whatever we may expand to. That's a different thing. So are you limiting it to just the 4 numbered paragraphs?
Yes, again,
That's it, with nothing else? No reference to expanding it beyond that?
well, this case is about the 4 asks on Appendix 313. And the auditor
So
has
those 4 paragraphs
said that
without any potential for expansion?
well, there may be another case.
Another
There is an
case, but here, that's it, just those 4.
For this case, correct.
And can I push you next? Because from
Yes.
what I understand, you've also been seeking that they file some kind of mandamus action. That's complicated legally. Are you insisting that they bring a mandamus action on those 4, or are you prepared to live with something more like Bates? Because that's another issue they may have problems with, bringing a mandamus action against the legislature.
So I have 2 points on that. One is in the correspondence between the parties, the Attorney General itself, the office itself said there may be ways around this mandamus issue. The state auditor, even though they are not the attorney here, the Attorney General is the attorney, the state auditor provided a very thoughtful legal analysis about distinguishing the limits case. But it's the Attorney General's job to figure out the legal strategy
Well,
here.
but they're worried that you're going to make them argue something they consider illegal.
Well, they can
So-
decide.
So
Or something that will cause negative consequences in the future. And that's something that is conferred to them exclusively.
But the correspondence wasn't that way, was it? The correspondence was the Attorney General asking, how are you going to get around the limits case? How are you going to deal with declaratory judgment not being available to the legislature? And what the state auditor said, well, I'm no lawyer, but here's what my thoughts. And that's where it stood. And then the Attorney General responded saying, well, maybe mandamus isn't maybe there are ways around mandamus, didn't identify expressly what the ways were. That's the way the correspondence went down, isn't it?
Yes, exactly. And again, in Secretary of Administration and Finance, this court said that only if the Attorney General finds no merit to the appeal can representation be denied altogether.
The state auditor's position is not that the SAG, if one is appointed, must bring a mandamus action.
The state auditor was asking the Attorney General as prospective counsel, let's discuss how we can do this. Let's discuss what the best course of action would be. And here are some ideas about how mandamus can be achieved. The Attorney General basically said, yeah, that might work, but then continued to ask the same questions over and over again, including what kinds of action do you plan to bring? It's very clear from the correspondence that the Attorney General was simply stonewalling the efforts. By never saying no, the Attorney General can stand here before this court and say it never said no. But in the course of more than a year, it clearly said no because it did not permit this voter-approved law to ever be enforced. And in so doing, the Attorney General has effectively usurped this court's role in deciding constitutionality of the state's law.
I don't see that. I don't see that at all, to be frank. The fact that a party and its counsel decide for whatever reason not to bring a suit to the courts does not mean that they have thwarted the court's authority to decide issues. The courts wait for the issues to come to them. So I would like to go to the question of a potential order. I take it that if you are prepared to confine yourself to these 4 numbered paragraphs in the January 6th letter, then the only thing from your perspective that's remaining is to see what allow the AG to come to a final conclusion with respect to those within a reasonable period of time to be determined by the court?
Yes, the state auditor would have no objection to that. We take the position that the Attorney General has already said no through her actions. If the court wants to hear an actual NO from the Attorney General,
Or it may be a yes,
Maybe a
or it
yes,
may be
or
a yes
maybe-
and no.
It may be no to you and they're going to do it themselves, or maybe it's yes to you and they're not going to do it, but we don't have an answer.
Right. No, the state auditor would welcome a definitive answer from the Attorney General so we can all know how to proceed. Because effectively what the Attorney General has done here is by claiming that the law allows her ultimate and complete gatekeeping authority, this is thwarting not just the state auditor, but
You're overstating their position.
Yeah.
Yeah.
Yeah, I mean, I think that the correspondence has been less than linear, having spent a lot of time with it. There's been identification of these 4 issues. There's been a statement that, no, it's not just these 4 issues. I'm starting here. There's been, statements back and forth about the legal causes of actions. And then there have been statements made in the public. So, it's not true that the Attorney General has stonewalled this case. There has been correspondence back and forth. And I think we're at a point where if you are willing to live with, and you are willing to live with these 4 topics, and that's it in this lawsuit, we give the Attorney General 30 days to determine the scope of the complaint that she is willing to bring or not willing to bring.
the
Or
state
she's
auditor.
willing to allow a special Attorney General to bring.
Yeah. The state auditor has repeatedly said in the correspondence that this litigation would be limited to those 4 issues. So there's nothing changing here about that. Now, if we're going to get outside the record, the Attorney General has made clear.
So there's been reference in the record to things outside of the record. That's only the reason I said anything.
Right. The state auditor has said one day there may be other things that would be another case. The state auditor has repeatedly said in answer every single time asked, this case would be about these 4 issues. That is all that is ripe. That's all that's present. That's all this court could even opine on.
Well, I think this exchange underscores part of the problem with the posture that the filing of this suit has put the court in. Ordinarily, we are not supposed to be sitting here interpreting a series of correspondence between a client and its attorney before any litigation has been filed to determine what they're each thinking. I'd like to turn to your actual complaint. It doesn't name the Attorney General, and it also doesn't identify any causes of action. What are the causes of action?
The causes of action, the issue before this court right now, obviously, is whether this case can even proceed. Can it be amended if necessary? Sure, any case can be amended, but because there is, one might say, some ambiguity in this court's jurisprudence regarding what cause of action will get the results that the state auditor is looking for, the current complaint is broad. It's simply seeking enforcement of the law.
It doesn't identify a cause of action.
Well, it asks for the law to be enforced.
It asks for relief, but without a cause of action.
Okay, but again, the question of whether or not this particular complaint is suitable or not is not the basis for the Attorney General's moving to strike it. The Attorney General has moved to strike it, and this court has taken up the issue simply of whether that motion to strike should be granted or not. So getting into the legalities of the underlying dispute is what we're happy to do, or whoever is arguing.
But I think what the Attorney General is the point the Attorney General is attempting to make is that the deficiencies of the complaint underscore why it is premature, because there's been no input by the Attorney General or another, or SAG or whatever, in crafting the complaint in a way. And so it's sort of like a premature birth. It's just come here without the process that should ordinarily occur before such a document is filed.
There was nothing stopping the Attorney General over the course of this year to actually engage with the state auditor in crafting what a complaint should look like. The state auditor went to the Attorney General as its potential counsel and basically said, we need to bring this case. Let's bring this case. The Attorney General's job under the law, the law that the Attorney General must follow is A, it must enforce the laws of the Commonwealth. B, it must enforce the public interest, which is clearly stated here. The Attorney General never.
We have a statute.
It simply tried to block this.
To simplify it, there's a statute passed by an initiative that says you can audit the legislature. Now, that parts of that statute may be unconstitutional, the whole thing may be unconstitutional, I don't know, but your cause of action is the statute is being violated because the legislature is not complying, and we're asking you to enforce it, right? That's what this basically comes down to.
Yes, and whether you want to call that mandamus, declaratory judgment, I mean, that's something to be gotten to in the underlying dispute. But the point is that the Attorney General never played the role of the attorney for the state auditor to figure out how to enforce the state's law. And in so doing, the Attorney General is it's not just a question of thwarting the auditor, it's thwarting the people, because under Article 48, the people have a co-equal right to make a law with the legislature, and that is what they exercised through the ballot initiative process in 2024. The Attorney General has an obligation under this court's precedent to not engage, not to block action in a way that is arbitrary, capricious, or unlawful. It's not just arbitrary or capricious, it's unlawful. The reason the Attorney General's actions in not allowing this case to move forward is because it is unlawful. Under the law, the Attorney General must enforce the law of the Commonwealth. If the Attorney General does not agree with that law or finds it repugnant, the Attorney General can appoint a special Attorney General, and then the Attorney General can take whatever position she thinks is best, but she can't simply not
They have
let
a
it get
little more
to the
power
courts.
than that. They have the power to control litigation and sometimes not bring litigation. So they may be exceeding that power here, but it's not just simply they have to do something. They make decisions. A law may be unconstitutional and they're not going to enforce it. They do that, and they tell state government regularly, you're not going to be able to do this. So it's much more nuanced than you're making it out to be.
Yes, Justice Koffer, I agree with that. What I'm saying, though, is that this is not a run-of-the-mill dispute over some arcane dispute over statutory interpretation. This is an important constitutional issue in which, again, if the Attorney General thinks this law is unconstitutional, then the Attorney General needs to appoint, or this court needs to appoint, separate counsel to defend the law. The Attorney General can then take whatever position she wishes in court. But again, blocking this issue from even getting to the court gives the Attorney General this super authority over co-equal constitutional officers. The auditor has her own statute that allows her to enforce her responsibilities and her duties, and the Attorney General is thwarting that if she doesn't allow this case by some means to get to this court. So this court has the power under its authority, under its precedent, to either order the Attorney General to allow this case to go forward with a special Attorney General or appoint separate counsel itself.
Okay, thank you so much.
Thank you, Your Honors.
Quiet, Clark, please.
SJC 13877, Claire Fitzmaurice et al. Versus City of Quincy et al.
Okay, Attorney Davis.
Good morning, Your Honors. May it please the court. My name is Joseph Davis, and I represent the appellants, the City of Quincy and Mayor Thomas Koch. I'm joined by James Timmons, the city solicitor, and my colleagues Eric Rosbach and Andrea Butler. Your Honors, firefighters and police officers across the Commonwealth and the country understand the figures of Florian and Michael to symbolize the values of courage and self-sacrifice that they seek to embody in their professions. The City of Quincy does not violate Article 3 of the Declaration of Rights by honoring its first responders with statues of these figures. And that conclusion is confirmed by Article 3's own text, history, and purpose, by this court's precedent, and by the longstanding tradition of similar statues on public property across Massachusetts. And on that last point, as a quick example, on my way into this court's courtroom this morning, I walked by this court's statue of Moses in the Great Hall. Right next door at the Suffolk County Courthouse, there's a depiction of Moses above the main entranceway holding the Ten Commandments. In the Worcester Courthouse, there's another statue of Moses. Why does Moses appear in all of these courthouses?
How many fire departments and police departments in the Commonwealth have statues on the front of the building itself of either St. Florian or St. Michael?
I'm not aware of any others in the Commonwealth, Your Honor.
Right, so that may seem, wouldn't that be part of history and tradition as well, that this would be the first one in the Commonwealth?
Well, Your Honor, I do want to point out that a number of fire departments, I mean, the majority of fire departments across the Commonwealth use the Florian cross as part of their symbol.
Okay, but I didn't ask that question. I understand, I saw that in your record, that they're badges, but we're talking about these actual religious figures as statues on the front of the buildings, and they're, I take it they're just none others in Massachusetts.
Well, I would dispute that their religious figures are at least exclusive.
Okay, Florian and Michael. Just call them Florian and Michael. I take it that there's not another fire department or police department in the Commonwealth of Massachusetts that has these as statues on the front of the building.
There's the Los Angeles Fire Department, the New York City Fire Department, the Bristol, Connecticut Fire Department, New York City Police Department, Bristol, Connecticut Police Department.
Okay, so none in Massachusetts, and you've come up with 3 out of the probably hundreds of thousands of police and fire department buildings in the country.
Your Honor, I do want to draw...
And I don't mean to quibble about the numbers. I'm just trying to, you started off by saying the history and practice in this Commonwealth. And that piece of it is part of the history and practice, right? This absence.
I mean, I think, I'm not sure, Your Honor. I want to draw an analogy, right? Because the reason that the Moses statues are relevant, and there's a number of other statues, obviously we've identified a bunch in our brief, pages 29 through 69 of volume 2 of our appendix. The reason the Moses statues are relevant, I think, is that Moses is obviously a figure that has religious significance for lots of people, for practicing Jews, Muslims, and Christians. But the reason that he appears in courthouses is because over time he's come to take on a broader significance as representing law and the legal profession more generally. And I think something identical to that, something precisely analogous to that, is going on at the Public Safety Building in Quincy. The reason that these figures are being proposed for the building is not because of their religious significance. They do have that, although not only for Catholics and Christians, I would add. But the reason that they're being proposed for the building is that over time they have come to take on a broader significance as representing firefighters and police officers more generally. And you don't have to take that from me.
Can you understand that significance without reference to their, I'll just call it hagiography?
So I would encourage you, I mean, you don't have to take this from me, Your Honors. You should take it from the firefighters and the police officers themselves. So in this case, you have before you amicus briefs filed not only by Quincy's own fire and police unions, but also by the 3 largest organizations representing firefighters and police officers in the country. And that's the International Association of Firefighters, the Fraternal Order of Police, and the National Association of Police Organizations. These are secular organizations, obviously. Together they represent, I think, nearly 1 million firefighters and police nationwide, and they've come before you and they've told you, like, yes, like the city of Quincy is right about this. These are the symbols that represent us. They have a significance that transcends religious lines, and they really do embody the core virtues that firefighters and police officers seek to display when they go to work every day. And so, I mean, I think that's the reason they would go up on the
But
building.
rather than zooming out to that, why don't we just focus on this case?
Yes, Your Honor.
So in response to Justice Wolahojan's premise, you said that you would push back on that these are religious symbols or so, or I forget what the phraseology, but if you look at the contract language commissioning the statues, it says Saint Michael, the archangel, the patron saint of law enforcement, and Saint Florian as protector of the firefighters. So why is that not contemporaneous evidence of a religious purpose or effect?
A couple of reasons, Your Honor. I think the first, most narrow reason is that I don't think the record even reflects where that language came from or who it's really attributed to. So it seems like kind of an odd thing to latch onto to try to delve into the decision maker's heart of hearts or something like that. But I do want to. I mean, the city is not disputing that those are the names of these figures, or at least how they're often referred to. But I don't think that really. I don't think that really contradicts my point, Your Honor. I mean, for example, on the Boston Common here, there's a plaque called the Papal Mass plaque that's about Pope St. John Paul II. And it obviously calls him that when it's saying, who the plaque is about. Moses is depicted holding the Ten Commandments. That's, of course, his traditional religious iconography and also non-religious iconography. So I don't think referring to them by common names is really all that dispositive.
Well, it's important because if the idea, and you go back to the amicus briefs that have been filed, if these statutes inspire first responders, and that depends on their traditional roles as protectors of firefighters in the police, is the city asking us to separate the secular kind of professional meaning of that from the religious intersection that gives those symbols their force? I mean, that's what gives them the force, right?
So, Your Honor, I don't think it's so much about separating. I mean, I don't want to keep going back to the well too often, but why is Moses associated with law and the legal profession? It's because, he's understood as having been a lawgiver, on Mount Sinai. So it's not about separation. It's about taking on a broader significance, Your Honor. And, another example, in the Boston Public Garden, there's...
a good example, why don't we start with Colo? Colo has... The chaplains are giving a prayer or some kind of admonition to start, and we said that was okay, even though it was clearly had a religious component to it. So that's your best argument, right? Not that it's secular. I mean, it's a mixture of secular and religious, and Colo seems to struggle pretty intelligently with this, although we've got the lemon stuff, but Colo says we look to history and purpose, then we can't provide less protection than the feds, so it provided the federal test at the time. So isn't Colo a good starting point for how we go about this? And
Absolutely, it is, Your Honor. And you're correct that this court, of course, never disputed that the prayers had a religious nature. They were, prayers delivered by Catholic priests. So that would be almost a nonsensical thing to try to say. I think Colo is binding law. I mean, it's got the lemon stuff, as you say, Your Honor.
I'm trying to figure out what in Colo, because Colo is a pretty comprehensive decision. It doesn't just apply the lemon test, and it provides cautions. It seemed prescient that Lemon was going to have some problems with it. So we start with purpose and history. There's also some sense even in that history evolves in Colo. So isn't Colo where we start with some modifications to Lemon? I'm just trying to figure out the law we're applying here.
Yes, Your Honor. We've proposed text, history, and purpose, which is this court's ordinary methodology when it's interpreting the Constitution. But I think Colo is fully consistent with that. And I agree with you, Your Honor. I think you could track Colo up and down. So where does Colo start? It talks about, what was the First Amendment, and then also the provisions of the Massachusetts Constitution. What are the kinds of things that they had in mind? What were the abuses that were going on at the time? Here, I don't think the plaintiffs have identified a single example of sort of religious imagery or mixed imagery that was on anybody's mind at the time that Article 3 was.
Your articulation of text, history, and purpose frightens me, and it seems brewing-like. Can you Is that what you're proposing, that we go?
No, Your Honor,
to
it's
the Bruin
Barron
to
versus
cause us-
Kalinda-like.
cause
It's Barron
us
versus.
lots of-
I'm sorry, I didn't mean
Lots
to
of
talk.
concerns?
I'm sorry, I talked over you.
Yeah, distinguish your text history and purpose from what SCOTUS has done in Bruin.
It's not Bruin-like, Your Honor. It's Barron versus Kalinda-like. So, I mean, our basic point is that obviously, the text of the Constitution is a starting point, but I think history matters, and Kolo explains how history matters, right? So, as I was just discussing with Justice Kafker, Kolo walks through the history of the framing of the First Amendment, and then we would say you should add the Article 3.
It goes through our history.
It goes through our.
We start with a constitutional provision that allowed basically money to be taxed to support one sect. And then we said, okay, we're moving away from that. And Kolo has language about history. Certainly the degree of intermingling of religious and secular life was much greater at the time the First Amendment was being debated than it is today. So it may not do Klinger-like modernization, but it contemplates change, doesn't it?
I think it does, Your Honor. We're not trying to say that anything, any developments should be off limits for this court. I mean, I think the upshot of, plaintiff's argument about taking into account modern developments and saying that this is a religiously diverse Commonwealth. I mean, we would agree. And we would say that the upshot of that ought to be for courts to not be, policing public symbolism for, its alleged religiosity. I mean, within the limits of Kolo.
But is there some element of sectarianism in this, though? Because that clearly was on the mind of our framers, right? And eventually, at least in 1833. So is there an element of preferring one religion here that we should be concerned about?
No, Your Honor, there is not. And that's true not only because these figures...
Why not? Because these are two Catholic symbols. Does that heighten our attentiveness to this?
Well, Your Honor, they're not only Catholic symbols. I think that's quite...
They're not only, but they're, at least originally, they're saints because the Catholic Church made them saints, right?
I think within so I won't keep pushing my points about the broader significance. I'll talk about within the world of religion, right? What you actually have before you also, briefs from the Muslim perspective, from a Jewish perspective, from a Russian Orthodox perspective, saying that we also care about these figures. I mean, Florian is a figure of history who, the legend says he put out a fire. So it should be not all that surprising that firefighters would think that this is a...
But the fact that there are more religions doesn't seem, who recognize these as religious figures doesn't seem to me to advance the notion that they're more secular.
Right, I was trying to distinguish between those two different ideas.
Right,
Honor.
so it's like, it's even more religious doesn't make it even more secular.
No, I would say both are true, Your Honor. These figures have a mixed significance, a broader significance than just a religious significance. They've come to represent firefighters and police officers, whatever their beliefs or background. But even if you focus on the religious part of their significance, which we haven't disputed that some people might view them as religious, even within that narrower focus, they're not exclusively associated with one.
Is the new building going to be the only police and fire department building in Quincy?
It is the new public safety headquarters. I think that's probably true, although,
Okay, so the headquarters will be, and this ties into Justice Kafker's question and at least in my mind, which is if this is, the police department and the fire department headquarters are places that will provide necessary public services. And so the citizens of Quincy will need to use that building, will need to have access to that building. And in that context, why doesn't it heighten our concern about this government speech that's embodied in the two statues?
I don't think it differentiates this building from courthouses, for example, which of course citizens need to use. And I do want to say, I think this would be a significantly different case, obviously, if there were some allegation of differential treatment based on anybody's beliefs.
Well, this is a problem for you because downstairs there are 18 or 16 statues. Moses is one. and they're all law related, so that there's a context. But these are going to be the only two statutes.
Well, I mean, I wouldn't say that's invariably, so you're right about the Great Hall, of course, Your Honor. I don't think that's invariably true. The Worcester County Courthouse, I think it's more of the standalone variety. But I think the context that matters here is that this is the fire and police building, and these are the figures that represent firefighters and police officers. So if these figures were put in, a more random location, I could see how that would be troubling. But I mean, as I said, the 1 million firefighters and police officers are coming into this court and affirming that we represent people of all faiths and none, and these are the figures that embody the virtues they seek to display. On the Colo point, I do think it's kind of a rich irony in this case that plaintiffs are presenting this case as a choice between our approach on the one hand and Colo on the other, because we would say Colo absolutely supports us and is in fact consistent with our analysis. I mean, you run through Colo like we were doing earlier, even on the purpose point, right? Colo says, what are the secular purposes that are served by legislative prayer generally? It's not sort of an effort to dive into what was going on with the legislators that crafted the chaplaincy statute.
Can I ask you, we're here on a review of the preliminary injunction. And you're, you in the Lemon test or Colo test, the first is the secular purpose, but here the judge found that the purpose was not secular. What do we do with that in light of our limited role in reviewing the preliminary injunction?
No, I think that's an important question, but the
I thought so.
Yeah, the judge. The judge, I think he didn't actually make a fact finding about what was the purpose behind these statutes.
Just didn't believe the mayor.
He didn't believe the mayor, which
and used McCarthy's statement,
which we find troubling. We have a sworn affidavit, of course, that has never been crossed.
Was there an evidentiary hearing, or it's all done on documents, right?
It's all done on documents. The plaintiffs didn't ask to cross-examine the mayor. But I want to focus on what the Superior Court did say, which is that basically based on the religious nature of these statutes is how he put it, that they lacked a secular purpose. And I think that's a legal argument that's squarely contrary to Colo. I mean, what Colo explicitly says, these prayers have a religious nature. Of course they do, right?
Don't we defer to his finding of a likelihood of success on the merits for PI?
I mean, not if it's based on a legal error, Your Honor. I mean, if it's based on a legal error, that's per se an abuse of discretion that's justified vacating the preliminary injunction. And I do think it's a legal error under Colo, because again, Colo says there are secular purposes to legislative prayer generally. It's not like what was going on in the legislators' hearts that crafted the legislative chaplaincy statute. It was these prayers serve to solemnize government proceedings. And it's a highly analogous purpose to the one served by these statutes. They serve to solemnize.
You're saying it's a legal error, but what Judge Sullivan ultimately says is, I discredit the mayor's affidavit.
He doesn't say that, does he?
Well, at least as to the part about what the basis was for the religious basis for choosing the statute.
I don't think he says that, Your Honor. But even if he did, our point is that
he said his statement is self-serving, right? He didn't say he didn't believe him. He said it was. I don't know but we're in the same position to evaluate those affidavits. Justice Gaziano's question is a good one. How do we analyze reasonable likelihood when it's on documents?
You're in exactly the same position that the Superior Court was in to evaluate this affidavit. It's not like he was making a credibility determination based on having seen the witness or something like that.
Our case law would suggest otherwise.
Well,
that trial judges do get to pass on the credibility of affidavits, and we say this in the context of motions for new trial all the time, that self-serving, he doesn't have to credit that. But let me ask a more pointed question about that.
Yes, sure.
Aside from what you filed in front of Judge Sullivan with the mayor's affidavit, was there any other evidence that was presented to Judge Sullivan in making that determination about whether the city considered any other non-religious alternatives or selected these figures through some kind of public process rather than them just being the patron saints of firefighters and the police?
I mean, the evidence as to the mayor's purpose and thinking was totally one-sided at the Superior Court. I mean, his evidence, or his contemporaneous statements before the affidavit were exactly the same as what he said in the affidavit. Mm-hmm. We had the firefighters and the police, his point was, I'm putting these up for the firefighters and the police officers because these are symbols that represent them. And then you had the firefighters and the police officers come into the case, try to intervene and say, yes, he's right, these symbols represent us. So it really is,
But there's also the clandestine nature of what the mayor did. And that figured into Judge Sullivan's analysis that it wasn't done publicly. It was done sort of secretly.
Well, I mean, we would dispute that, those adjectives, obviously, Your Honor. I mean,
Clandestine's not accurate?
well, it was done, I mean, I guess that sort of has a connotation to it that, I mean, it was done late in the process because this building was built according to the construction manager at risk process, the whole point of which is to allow flexibility. So there's no doubt that, the mayor testified, it was as we were finalizing the facade of the building that we realized there's room in the budget, we like public art, and we'd like to put some public art.
Any precedent for a major piece of public art being done like this? Usually there's tons of process, right? Art is controversial in general, right? People have strong views. That's got to be a factor to consider, isn't it?
I mean, if you had a procedural claim, something like that would be a different case. It might be a really interesting case, but I'm not sure what the upshot of all this is for the Article 3 question, because even if to our colloquy earlier about the affidavit, assume that the judge did, dismiss the affidavit in whatever way that this court would defer to. I'm not sure that's correct, but you're still left with, do these statutes, do they serve secular purposes as a general matter? That's what the Colo question is. The Colo question is not what was in the head of the people who crafted that statute, that legislative chaplaincy statute, here selected these statutes. Instead, it's, do these statutes serve secular purposes generally? And I think the answer is yes, based on what the firefighters and the police officers have told you. And I really think you would have to do one of two things in order to rule against Quincy here. I think you'd have to either say, number one, the firefighters and the police officers are just wrong, and that these statutes really are just religious.
Well, is that really the aperture, though, or is it what's in front of what was in front of Judge Sullivan? What Judge Sullivan's decision is based on is what we're looking at. Do you have all of that in front of him?
Well, he did, Your Honor. So he didn't have he had one out of the four amicus briefs that I was running down earlier, but he also had all the evidence that underlies those amicus briefs. The city put in evidence about the Floridian cross in fire department logos.
Can I ask you how we measure the perception on the secular part of it? So if a citizen of Quincy is driving down the road and sees it, and they see this big angel smiting a demon, and someone has to explain to them, oh, that's actually the symbol, that's St. Michael, is the symbol of good versus evil in police departments. Isn't that kind of a niche explanation that when you see this, immediately it strikes as overwhelmingly religious?
Well, Your Honor,
and you have to crane to see that St. Florian is actually holding a pitcher of water, right?
Yeah. I mean, I'm not so sure. I think Moses holding the Ten Commandments strikes most people as religious. I think this kind of gets into the issues with this sort of objective observer. Is this endorsing religion? Is this not kind of test? I mean, plaintiffs really want, they've got like a Goldilocks objective observer. It's somebody that doesn't know too much about these statues in order to know that they are the symbols of firefighters and police officers. Also doesn't know too little.
Well, think about the person who's driving to Roxy's to get their bargain meat, right?
I'm not sure that person knows who these figures are, Your Honor. I think that's kind of
the second one doesn't look religious, right? It looks like a Roman soldier.
It looks like a Roman soldier, Your Honor. And I don't think there's any kind of no angel rule either, right? There's a famous angel in Central Park in New York City. There's an angel in the Boston Public Garden. I think all this discussion gets at kind of the uncertainties of their test. And this is not a question that Colo asked, right? If you look at how Colo approached the effects part of the analysis, or at least what it called that, it didn't ask, would an objective observer view these prayers as endorsing religion? Again, kind of a strange question. Instead, it said, are these prayers likely to meaningfully change people's religious practices? It said no, because, this, unlike in a school, right, this is in a legislative chamber. It's not a pedagogical context. It's not a place where the whole point is to influence impressionable school children. I would say that the public safety building is a lot more like a legislative chamber than it is like a school. So if you use Colo's analysis, not necessarily what it invoked as the criteria or the guidelines, which, as Justice Kafker said, were at that time the Lemon test. There was, of course, a federal establishment clause claim in Colo in a way that there's not here. If you use its analysis, that analysis is fully binding. We're comfortable with it, and I think it cuts strongly in favor of the city in this case.
Okay. Thank you.
Thank you, Your Honor.
Attorney Rossman.
Good morning, Your Honors. Jesse Rossman on behalf of the appellees. With me at council table are Rachel Davidson and Suzanne Schlossberg. Our Massachusetts Constitution protects the right of private individuals and religious institutions to display religious statues, and they often do so to indicate that a particular building is meant for people of a particular faith. But our Constitution equally prohibits the government from installing new religious statues as the sole adornments on a prominent government building.
Can you give me the intellectual basis or the basis for new versus existing?
Absolutely, Your Honor. And I think this is something that was reflected both in Colo itself, where this court looked to the fact that the long-standing, consistent history of something which existed with legislative prayer and doesn't exist with the statutes at issue here is something that can be taken in consideration. The federal Supreme Court did the same in American Legion, for example, distinguishing between old statues and the new installation of statues, and that might have an impact. And I think that cuts in at least two places, Your Honor, when you're looking at the Colo test. That's both with respect to effect and with respect to divisiveness. So with respect to effect, there may be a different understanding when statues that were erected over 100 years ago, which the vast majority of the statues that the defendants reference in their brief were, what kind of historical meaning that is taken on today that might be something that has become secularized. And I think the Bladensburg cross, I really worked on trying to pronounce that correctly. I thought I was going to get it and I didn't. That cross had been in place for over 100 years, and it had become a site for veteran memorials on a regular basis. And so it had taken on a secular meaning, in part because of the length of time that it had been in that location. And I think another indication, Your Honor, is divisiveness. One of the things that Justice Breyer talked about in the Supreme Court was something's been around for decades at a time and there's been no division. That's something that can be an indication that it's not violating our religious protections clauses. But of course, here we have something that is the decision of the Quincy government today to erect two new statues that, as the unrebutted expert testimony from Professor Byrne makes clear, reflects the specific Catholic iconography of St. Michael the Archangel and St. Florian. And it is certainly something that has caused division prior to the litigation in the city of Quincy. And the record is replete with that evidence. And so we think that the Superior Court was right to determine that the plaintiffs were likely to succeed on their claims here.
The Superior Court does a heavy lemon analysis. It doesn't really look to the rest of Colo, Colo begins with some important points about history and purpose. And then it also talks about, it's concerned about, let me read you this sentence. The long history of a certain practice, however, and its acceptance as an uncontroversial part of our national and state tradition do suggest that we should reflect carefully before striking it down. Colo has a lot of the modern day Supreme Court stuff that, as well as Lemon versus Good, but the trial judge really focuses on the four-part test almost exclusively, doesn't he? And I'm just worried that these symbols have a long-term meaning. I understand this is a new statute, but the symbolism for police and fire has been around a long time. And the Supreme Court's cautioning us not to, and Colo says the same thing. There's not a hermetically sealed or separation between church and state. Some of it's allowed based on historic traditions and just sort of the way we live in this country and state. So I'm just trying to figure out why this crosses the line when the legislative chaplain one didn't cross the line, when it was also a Catholic chaplain historically in the legislature too. Are you saying that's wrong? Colo's wrong on that point?
No, Your Honor, we think this court got Colo right. And I think it should give this court great comfort, in fact, that the Colo test in that instance ended up upholding the state practice. It's not a toothless test. It's a real ability to analyze the specific fact pattern that's at issue in a given case to determine whether or not it's violating Article 3. And the very criteria and elements that this court looked at in Colo point in the opposite direction when we're talking about the St. Michael the Archangel and St. Florian statues that are at issue in this case. So in Colo, Your Honor, what the court focused on was the fact that these were temporary, these were brief prayers, it was voluntary whether or not individuals were engaged. The state had no role in choosing what the content of the invocation was. And while it was true that the history had shown that over the past 20 years there had been Catholic chaplains, there had also been additional diocesan chaplains, that had come in to present prayers of different denominations during that period of time. It wasn't set in stone. And it also turned in large part, Your Honor, on the unique historical pedigree of legislative prayer, which has been consistent and constant since the founding. Those things cut in the opposite direction
But
when we look at this
statues,
case.
we have a lot of statues in public places with religious elements to it. Massachusetts has a lot of them, right? They do a good job, and I mean, in some of the amicus brief, the police department has an "In God We Trust" on every badge. I mean, we've got all kinds of that out there, and I'm just worried how this fits in with that world.
I think it fits in quite nicely, Your Honor, and I think Colo itself, looking at that history and purpose, which I don't view as a separate part of the test, Your Honor, as I understand reading the decision, the court articulated those principles and then walked through those 4 guidelines of effect, purpose, divisiveness, and entanglement, and considered it within the context both of history and purpose, as well as the current context. And I think there's really significant contextual differences, Your Honor, between many of the statutes that are cited in defendants' briefs and that are right here in the Commonwealth. We look to context. Is it solitary or is it surrounded by other figures that have a secular meaning? Does it have pride of place on the outside?
What are the other figures that have meaning to police officers and firefighters? What other figures would you anticipate would be required in order to make this constitutional?
Well, Your Honor, I think one option could be, I know that there have been many heroic police officers and firefighters that have performed duties here in the Commonwealth and elsewhere.
So if we had St. Michael, St. Florian, and real other people, then that would pass constitutional muster.
I think it would depend on the context, Your Honor, but I actually think that's one of the reasons why the Colo test is so helpful to retain, because as this court said in McDuffie, our constitutional provisions provide general principles. They're not a specification of details. And so lower courts need guidance and a framework to analyze when something violates a constitutional provision. The 4-factor guidelines that Colo provides gives lower courts the ability to do exactly that. And in this instance, the record...
There's been so much criticism of those particular 4 factors. And that we're going to certainly have to take another look at those. Whether those particular factors, there's a lot of, particularly the purpose one, because there's always multiple purposes. So it just seems, are there any cases where we've struck down, any examples where we've struck down something like this? I'm just, because Colo, the most analogous was I'm just trying to, good examples where we struck something down, a statute somewhere like this.
So, Your Honor, to my knowledge, I believe that there was Colo, and then this court in 2004 reaffirmed the Colo test in the Society for Jesus case. But there hasn't been applications of Colo since. And that makes sense. If you look at states throughout the country, many religious freedoms cases had been brought in federal court and not in the state court system until recently. But I encourage the court, the Colo test is workable, and the Borgman amicus speaks to that. And the mere fact that the Supreme Court is either unable or unwilling to faithfully apply it doesn't change the ability of this court and the other courts in the Commonwealth from being able to do so. And in fact, this court has a pedigree of continuing to retain workable tests.
How do we determine if there's a secular legislative purpose?
So, Your Honor, I think in this case, taking, and I know we've had some discussion about whether or not the Superior Court credited the mayor's statement, even taking the mayor's statement at face value, because as this unrebutted expert testimony in the record below show, the purpose, the inspirational power of these two statutes is inextricably intertwined with its religious underpinning. And that's not just from the plaintiff's own expert testimony. It's also, I'm sorry, Justice.
No, please, I want you to finish.
It's not just from our plaintiff's own expert testimony, which is unrebutted. And I will say that was the record before the Superior Court, not the amicus briefs that have been filed before this court. But it's the defendant's own exhibits that were before the Superior Court itself, which time and again reference the religious roots and the power of prayer when they're talking about the inspirational value of St. Michael and St. Florian. So there may be closer cases. And I think, Justice Kafka, you had mentioned in the Kaplan case that in these kinds of analysis, there is line drawing, and that line drawing is sometimes difficult, but it's also necessary. And the advantage of the Colo test is it gives a framework for that to be able to apply.
So you spoke of other factual records in other cases, but we're obviously at a very preliminary stage of this case. So would you concede that if this case, obviously will go back down one way or the other, and if Quincy built a huge factual record showing well beyond anything we've seen here that, these Florian and Michael are essentially the mascots in kind of a sports team way of police and firefighters all across the country of every different religion. And it's not just about prayer, but it's just this encouraging symbol like gritty or whatever, that would be enough? Or are you saying that the well is poisoned because they originally came from a religious tradition?
I think what we're saying, Your Honor, is that this record supports the preliminary injunction.
I'm not asking about this record. I'm asking about, you said that in another case, there could be a showing that a religious symbol had taken on a secular meaning. And I'm not asking you about the record before us, which I understand we are constrained to, but my question is, these particular symbols, Florian, Michael, St. Florian, St. Michael, is your position that there's no possibility of building a record about their meaning in the police and firefighter community that could ever win under Colo?
Your Honor, we would of course have to take that record as it comes, and I do think again that Colo provides a helpful framework to be able to do so. There is already an existing record right now, which would have to be a part of that, of course, but I take Your Honor to be saying outside of that. So all we are asking this court to do today is essentially two things, and that's to reaffirm the test that has already been in place for 50 years, and to, on this record, determine that the preliminary injunction needs to stand.
Can I go back? I'm sorry. So a couple of moments ago when you were answering Justice Wendland's question, something jumped out. Are you localizing this to the Catholic faith specifically? Because you keep saying religious affiliation, and we have here, the record is clear that this is important to Jewish traditions, Muslim traditions, several different Christian traditions. And so are you saying that we should, how are you saying we should treat these statues as specifically being Catholic or more broadly, something more general?
So I think there are two important answers to your question, Your Honor. First, as Justice Wolhogen said earlier, adding more religion to these statutes does not remove the Article 3 problem.
Why not? Because Article 3 specifically says no subordination of any one sect or denomination to another. So the fact that multiple sects find this symbolic does seem relevant, at least, to the Article 3 inquiry.
Well, I think the text of Article 3, Your Honor, encompasses a general principle of government neutrality and not raising one religious beliefs or religion in general above non-religious beliefs. And even if there were 3, 4, 5 religions that found these figures to be important, that would still be elevating religion over non-religious beliefs. But I think an important second piece of the answer, Justice Georges, to your question, is the unrebutted expert testimony from Professor Byrne that these particular statues encompass the Catholic iconography of St. Michael and St. Florian. Professor Byrne also talks about the fact that other religious faiths, like Judaism, do not have saints. So they might be figures in their religion, but St. Michael, the archangel, and St. Florian, as they are depicted on this building, directly reflect the Catholic iconography. And I want to be clear, if there was a statue that directly reflected another religion, if there were 2 10-foot tall Jewish stars or 2 10-foot tall moon and crescent and stars that were outside the building, it would pose the same issue.
Well, but that goes to the bigger problem, because I'm trying to figure out what the framing is here as to what you think the Article 3 complaint here is. So is it that it prohibits endorsement generally? Is it that it prohibits denominational preference specifically, or legal operational subordination? You've touched on all of these, but what's the complaint here with these particular statues? Which is it?
These statues, Your Honor, are conveying a message that a particular religion is being elevated above other religious and non-religious beliefs. Now, I do think that the Article 3 language about non-subordination and the Equal Protection Clause encompasses a comprehensive notion of government neutrality towards religion. It doesn't require a hermetic ceiling.
Can I push on that point a little? Because, and again, I'm reading from Colo, because Colo, again, it anticipates some of the stuff the Supreme Court started moving to. I'm reading, rather, it studiously defines the manner, the specific ways in which there shall be no concert or union or banquet. That is the common sense of the matter. Otherwise, the state and religion would be aliens to each other, hostile, suspicious, and unfriendly. The U.S. Supreme Court is really concerned about government action that appears to be hostile to religion. And I'm trying to understand, they could put up statues of almost anything in that building, right? And they can't put these up. And I'm just wondering if that runs into because we can't provide less protection than the Supreme Court on free exercise, or, we can't allow more hostility to religion than the Supreme Court would tolerate. And they have very low tolerance. I'm trying to understand, if you could put up any kind of statue in this building, but you can't put up these ones that have a religious element to it, is the Supreme Court going to be troubled that that's singling out religion somehow in a way that's inappropriate?
I want to be very clear on the record, Your Honor, because I know this is something that opposing counsel has raised. There is no potential violation that is of federal law that is posed by the relief the plaintiffs are seeking here.
Can you talk a little louder? You're very tall and that microphone's way.
Sorry, I'm wearing heels too, so I think that's adding to it. I think there are 2 different elements. I apologize, Your Honor, if it gets too quiet again, let me know. There are 2 different elements that I want to address, both the free exercise issue and then this general notion of hostility towards religion, which I take the opposing counsel to be referring to the Establishment Clause and not the free exercise.
Well, the Supreme Court, some of the amicus briefs are straying. They're saying there's going to be an overarching sensitivity to hostility to religion. And the U.S. Supreme Court, again, its more recent jurisprudence is very focused on that.
It is, Your Honor, and the context in which that has arisen is critically different from what we're talking about here. So free exercise clause concerns come into play when the government is burdening private individuals or private institutions.
It's preventing grants, for example. The grants are the classic example, right? State funding, if the state is willing to fund everything else but not religious exercise, that crosses. That's the Supreme Court revised its jurisprudence to sort of focus on that, right?
It did, Your Honor, in the Espinoza case, and it talked about the fact that if other private institutions were going to get access to those grants, then religious private institutions also had to have similar access to the grants. But that's not the case at issue here. There is no private individual. That's part of the problem.
Right,
this is government speech. And it's the government using its platform to elevate a religious belief over the other beliefs of others. So I think squarely within what the court has said in Espinoza, in Masterpiece, in Kennedy, this does not run afoul of those principles. With respect to this blurring of the lines on hostility towards religion, Your Honor, I want to be very clear as well. Their neutrality, government neutrality towards religion is not the same as hostility towards religion. And this court need look no further. You mentioned the Supreme Court. The Supreme Court just last year said as much in the Catholic Charities case, where the court held the fullest realization of true religious liberty requires that government refrain from favoritism amongst sects. And we know through our practice and through the amicus briefs that have been submitted that government neutrality towards religion increases religious pluralism within a society and the ability to practice your own faith. And what the defendants are arguing for here would really torture the English language and twist Article 3's principles so it almost cannibalizes itself. Nothing that the U.S. Supreme Court has held requires that.
It seems to be, though, also is from whose perspective? Because if you're taking the perspective of the amici, particularly the firefighters and the police, I would presume that there's a heck of a whole lot of, they might be agnostics, there might be atheists, there might be Catholics, there might be Jews that serve on the police and fire in Quincy who are very much in favor of the fact that this has some professional meaning to them of their safety and guarding what they do. And so it seems to me to bring up the point that Justice Gaziano made a little while ago about the guy going to Roxy because brisket's on sale. Like, I mean, are we going to turn these constitutional kind of questions into kind of, I don't know, a heckler's veto?
Absolutely not, Your Honor. I think that's partially though why, again, the COLO test of looking at effect, looking at purpose, looking at divisiveness and entanglement on the record. And the record here shows that these are both religious messages. They're being received as religious messages. The Quincy Interfaith Alliance, which was 19 different faith leaders in Quincy, held the same. And again, the defendant's own records, I encourage the court to look at exhibits 4 through 15, where repeatedly the defendant's own exhibits reference the religious roots and the power of prayer that lead to the inspiration. It is not that someone who happens to be religious can never have a statue erected on a piece of government property. That's not the test. And that's not what the plaintiffs are asking for here, where you have 2 Catholic saints whose images match the specific Catholic iconography, whose power to inspire is directly connected to Catholic doctrine, and who are on the outside of a building that is meant to be welcoming and to ensure that people have equal access to the public safety services. That violates Article 3. And that's all we're asking the court to hold here.
Okay, thank you.
Floor, please.
Well, she finished strong there. Her the last thing she said was the whole case in a nutshell. Let's see if there's anything.
SJC 13893, Arcangelo Sella et al.
Come on.
Versus Andrea.
Before we go, I just want to see if there's anything that they didn't get to. Sorry. Here. So, they talked about Colo a fair bit. They didn't get into the fourth prong the way I thought they would. So I was wrong there. I thought they would be interested in knowing about the political division, which is the fourth prong of Colo test. But that didn't come up at all. Do the justices focus on history and tradition? Yes, and I think they were kind of suspicious of the defendant's position on that. I don't think the defense arguments about Moses, as an example, were landing. Do they talk about religious neutrality and inclusion? Yeah, and they talk about that at the end there. And they were pressing the plaintiff lawyer about that because one thing that they were saying, which I don't think we've talked about a lot, is hostility towards religion, and that comes up. That's the number 4, and they were asking, would denying these statues to go up be considered hostile towards religion? And I think that depends who you ask. I think if you ask that Facebook group who are constantly asking for the statues to rise, I think they would absolutely see it as hostile towards religion. I do not see it that way. I think the idea that you say no to something makes it hostile. Where's the end of that? If you ask the government for relief for any matter, and the answer is no, that doesn't necessarily mean that the government's being hostile towards your request. It just means it doesn't fit within the law. They didn't talk too much about Judge Sullivan's original injunction. They did. There was a few minutes there where they were talking, but they didn't seem to have many problems with Judge Sullivan's decision. And I think that is a bad sign for the plaintiffs. I'm sorry. I think that's a bad sign for the defense. They didn't seem to see much wrong with Judge Sullivan's rationale. And that's what today was really about. Did he err in granting the injunction? And I did not hear a lot to make me think that they feel that he did. The questions they posed towards the plaintiff, the ACLU attorney, do make you think that there's a possibility that they're going to issue some guidance on Colo's role going forward, which will be very important in this trial. But from what I saw today, I don't see any indication that the injunction's going anywhere. But I am an amateur watcher of these things, and it'll be interesting. I really want to hear from legal experts, and if any of you out there are following this closely, please write in info@adjustquincy.com. Let me know what you think. I'd love to talk more about this. And while we're waiting for the decision, maybe we can have an online interview with people who know about this to just review what we saw today. But anyway, I'll let everyone get back to work. Thank you so much for coming to the live stream, and I'll look for my